the Department of Justice, and at the same time, I'm the director of the MA in Peace, Security, and International Law, and one of the co-directors of the War Crimes Research Group. And today I'm very, very happy and honored because here at the Department of War Studies, we are very excited that we host and co-organize with the Global Institute for the Prevention of Migration. Migration, of course. Aggression. You see, everybody's in aggression, and I say my mind was somewhere else. Apologize. We co-organize this panel on aggression, contemporary challenges to the jurisdictional schemes regarding aggression. Before I introduce the panel and some very, very short introductory comments, I would like to say that apart from the Global Institute for the Prevention of Aggression and not Migration, this event is also co-sponsored by the Montreal Institute for Global Security and the European Law Students Association. So I don't think we could have a better and more truly expert panel than this one to talk about aggression, the crime of aggression, where we stand and contemporary challenges. We will start with Dr. Mark Ellis, who is sitting next to me, who is the Executive Director of the International Bar Association. Afterwards, we will proceed with Dr. Astrid Reisinger-Corazzini from Austria, Senior Scientist at Salzburg University and also member of the Steering Committee, Global Institute for the Prevention of Aggression. We will continue with Professor Noel I'm sorry, Noel, Director of Research and Enterprise and Professor in International Law at Bristol Law School, University of West England. And last but not least, Dr. David Donat Catan.
Perfect.
Finally, I did something correctly today, who is sitting next to me on the other side. David is an adjunct professor of international law at the NYU Center for Global Affairs, senior fellow with the Montreal Institute for Global Security, and also project coordinator and member of the steering committee of the Global Institute for the Prevention of Aggression.
JIPA, you can say JIPA.
JIPA. Okay, that's easy. So why do we have this panel on aggression, on the crime of aggression and current challenges? Here, especially at the Department of War Studies, it's impossible not to teach aggression, the crime of aggression, or the act of aggression, or the aggressive war, as that we say, within different modules I teach on international law and war, international law, peace and security. And of course, we start with the prohibition of recourse to force, the famous jus ad bellum, as we say in international law. We touch upon the prohibition of aggression as a peremptory norm of international law, as a jus cogens norm. And at the same time, we follow a parallel development of the crime of aggression, of the crime of aggressive war. We already from the Nuremberg trials, Justice Jackson spoke of the supreme crime, the crime of aggression. Usually, genocide becomes the key focus of students when they studied here, but the supreme crime is the crime of aggression, and developments that they were finally, I would say, substantiated within the Rome Statute in 2010 in the Kampala Review Conference. Finally, the crime of aggression was activated in 2018, but it's not the same crime. It's not a crime like the other core crimes we have under the jurisdiction of the Rome Statute. Clearly, the crime of aggression comes with an asymmetry very much related to its nature, to debates about its nature, about the controversy surrounding the crime of aggression. And we have seen that more vividly, I would say, after the Russian invasion of Ukraine and the inability of the ICC properly to deal with this aggressive war. So due to these jurisdictional asymmetries and limitations, another idea came up. And this idea was for a special tribunal for the aggression against Ukraine. And in this panel, our experts will discuss, we will address both, I would say, streams. From one side, the stream regarding developments before the International criminal court. But on the other hand, where do we stand with this special tribunal for the crime of aggression? What are the main challenges, political, legal challenges, but also challenges related to its legitimacy, to its relationship to the ICC, and what are the new initiatives, if I may say, of the Assembly before the Assembly of State Parties? How can the jurisdictional asymmetry, as we say, within the Rome Statute of the crime of aggression can somehow be corrected at some states with regard to the other three core crimes, the crime of genocide, war crimes, and crimes against humanity? Now, without any further delay, I would like to initiate this discussion by giving, first of all, the floor. And I'm very happy because this is a very mixed panel, I would say. We have academics, doctrinal academics, theoretical academics. I consider myself one of them, but also we have practitioners, people who are inside the real discussions. Without further delay, Mark, you have the floor.
Thank you. It's great to be here. Great to have this opportunity to discuss this fascinating development in international law. The idea of creating a standalone special tribunal for the crime of aggression in relation to Russia and others. I'll just say a few words. It's fascinating because when this first came about, this idea, I've been to Ukraine 14 times since the full-scale invasion. And my first visit there, this was not discussed. This was, lots of other things were discussed, the whole chaos that was occurring. But accountability did come up, accountability primarily domestically. And so that became a really focus area. But probably a year into it, in some of the visits I had, I began to hear about this idea that was coming from Ukraine. Philippe Sands published his op-ed on this, but Ukraine started talking about this. And it was fascinating to me because it was not something that was embraced wholeheartedly. I can tell you that because I remember being in those discussions. A lot of controversy in relations to the ICC, in relations to the reality of whether or not this could even happen. But I think the fundamental basis argument was, if, as Maria says, this idea of a preemptive norm, this idea of a prohibition against the crime of aggression, this idea of upholding the UN Charter and Article 2, all of that was at play. And I think it came down to this. If we're not willing as an international community to focus on the actions against Ukraine for the crime of aggression now, then it will never happen. This is the most prominent key example act of the crime of aggression, certainly since World War II. So I think that was the driving force. It was not just for Ukraine, because that was clearly prominent in Ukraine's desire to bring those to justice account who have the leaders who have initiated this war. But the discussions moved pretty quickly beyond that. This was important for the international. It was important for the legal principles that came out of Nuremberg. That's important to understand because that's what I think continues to drive this. So during these past 3.5 years, it's to me quite extraordinary that this tribunal has moved to the level and to the area it is right now. When you look at other accountability mechanisms, for those of us who are involved with the creation of the ICTY, the ICTR, and the ICC, those are fairly arduous journeys. This was too, but the fact that we have this now agreement as of last few with the Council of Europe that is playing the key role, and that you have a statute now that has been developed and that you now have the movement to create this tribunal. So the question is that I'm always asked, will the tribunal, will it come to reality? And the answer for me is absolutely will. And it's moving at a very quick pace right now. And what in the debating the creation of the tribunal, lots of compromises were made. And it was Ukraine that made this decision that we should sequence the development of this tribunal. And when I talk about sequencing it, it's really interesting what Ukraine has done and the Council of Europe has done. So they've created this three-part phase to create the tribunal. There was not sufficient support immediately to have it all done at one time. And that was primarily because of the debate on the cost, which is still an issue. How much is this going to cost? And states were hesitant to say, well, we're going to embrace this tribunal without knowing what the consequences from the cost were. So Ukraine has pushed it, and David had mentioned I published with Irina Mudra from the president's office and Ambassador Anton Koronovich, a article in Just Security, kind of setting out what this process was. And it's a three-phase process. There's something called an advanced party that is now set up in Strasbourg. That's looking at kind of the basic elements of what this tribunal will need in order to function. That will happen, that will work all this year. The European Union has given it $10 million, so it has sufficient money to kind of operate. It's a small group sitting in Strasbourg, beginning to look at how is this going to structure, what do we need in regards to the courts, what do we need in regards to all the structures. Then it goes to the phase two called the skeleton tribunal. And the skeleton tribunal will be in The Hague. This will happen sometime later on in the year, and it's just an add-on to this advanced team. But now you're getting pretty serious, because now you're looking at the selection of judges, the process of selecting or creating the registrar, the prosecutor. So this now becomes quite serious. But there's contingent on something that you will have undoubtedly heard about called an enlarged partial agreement. That's the foundation of within the Council of Europe, that you need to have states that are signing up, if you will, for financial support and to commit themselves to be part of this tribunal. And that's the enlarged partial agreement. And you'll hear about that now in the press and in the discussions that you're having. And the reason is because it's critical that the tribunal has sufficient number of states to say, yes, we're committing. And under the Council of Europe's kind of legal parameters, you have to have 16. But this tribunal and those that are creating it, they're looking at 25 to 30, if you will, signatures, commitments to this enlarged partial agreement, because they want this to be quite broad. And they want it not just to be states from the Council of Europe, but they want it to be states that are outside the Council of Europe. And it's quite flexible in how states can join this and commit to this EPA. They can be a full member, they can be an associate member. It all really comes down again to what I said, the financial commitment. And that's what's going to have to, that's still a bit of a gray area. But it is moving. We were just talking, I think we've got 20 states now who have made the commitment, who've publicly stated we intend to sign an EPA. There'll be other parameters of the steps that they'll have to take depending on which state is doing it. But there's no question that there is a commitment. My sense is in May, the end of May, you'll have the full number of states who have made the commitment. That's a remarkable development in this journey. And then it moves to the skeleton tribunal. And after the skeleton tribunal, well, you will also have a host state agreement between the Netherlands and this tribunal. Then it moves to the third phase, which is a fully operational tribunal. That's when you'll get your investigations, your indictments, and the arrest warrants. Let me just say two last points before I go, because I said that this process was quite arduous and it was controversial. And I want to mention two controversial issues that you'll hear about, you'll still hear about, particularly within civil society. One, under the statute, it's permitted to have trials in absentia. Now, trials in absentia are themselves controversial. In common law systems, as many of you know, you just don't have them. But in civil law systems, you do, but with kind of strict parameters. But there was a lot of debate going on in this core group who were working at creating this tribunal on whether trials in absentia should be created. And the answer was, they came to the compromise and said yes. So then the question for me was, is the statute consistent with international standards of undertaking trials in absentia? What are the requirements that international law sets out? And my response is yes. I think the statute does what it should do in the area of trials in absentia. So you'll see, and I suspect the first trials under the tribunal will be trials in absentia. But this leads to the second point, and that's head of state immunity. This was probably the most controversial point in the negotiations. There was something called a hardcore group within this group of 40 states that argued that if you recognize head of state immunity, what was the point of creating this tribunal? That head of state immunity for the crime of aggression, and remember the crime of aggression is a leadership crime. So the leadership crime means that the tribunal was going to go after the top players, including Vladimir Putin. And of course, under head of state immunity protections, the Troika would not be part of that, would not be permitted to be brought under the tribunal. They did a fascinating thing. When you read the statute, de jure, the statute does not recognize head of state immunity under Article 4. Really interesting that it says the tribunal, this new tribunal, does not recognize this protection of head of state or the Troika. Not only that, but we don't recognize functional immunity either. So for the purposes of this statute, the official position of any of the accused at the time of the alleged commission of crime, whether as a head of state, government, or a member of government of parliament, shall not relieve such person of criminal responsibility nor mitigate punishment. So the statute de jure says we don't recognize it. But here's the political compromise. And we have to recognize that when you're creating an entity like this, the compromises are going to be there. And the compromise was de facto, this tribunal will in fact recognize head of state. So the prosecutor can investigate, the prosecutor can put in front of the pretrial judge an indictment, but as soon as he or she does that, the pretrial judge must suspend any further action towards those that are protected under the head of state immunity principle. And it will stay that way until, for instance, Vladimir Putin is no longer head of state. That was the compromise. I'm convinced that without that compromise, we would not be here talking about the tribunal. It had to happen the G7 were particularly focused on ensuring that they're going to uphold this principle of head of state immunity, and they were not going to concede on that. And that was the concession, and that was the compromise. Personally, I think it was the right step to take. Others will disagree on that. But it does allow us to move forward with the creation of this tribunal, which will exist. But there'll be those that will argue, if you cannot go after the architect of this crime, which is Putin, then is it really worth doing? And that will continue to be the debate. But I come on the side that it is. And remember, there are a number of other players. It's an individual. The crime is directed at it's a leadership crime, and there are others who are not protected under the head of state immunity that would still be able to be brought into the tribunal. That's where we need to go. And lastly, it allows still the tribunal to investigate and to set out all the evidence and to set out even an indictment. And I think that's going to be very powerful for the victims as well. I'll leave it at that.
Thank you very much, Mark. Thank you for this wonderful start to our discussion. The next speaker is Astrid. I have to say that since I did my PhD, I remember Astrid, Astrid is one of the key people, in researching on aggression for many, many, many years. And I'm very happy that you are here with us. And my understanding is that you're going to address issues about the crime of aggression within the ICC statute. So that was Laura, Astrid.
Thank you so much, Maria. And maybe I should add, because this is an event that is co-sponsored by ELSA, that David and I, we both had the opportunity to participate in some of the negotiations in the PrepCom, David even in Rome, because the European Law Students Association was a member of the steering committee for the establishment of the International Criminal Court. So this is where I started.
Yes.
Okay, so I will continue and have a look at the ICC. I think the term compromise will come up a lot as well. When we look at the jurisdictional regime that we currently have for the crime of aggression, we need to go back to Rome, because it's one compromise after the other that kind of led us where we are today, and a situation that many would like to change. Now, you are all familiar with the Rome Statute and the default jurisdictional regime that we have in the Rome Statute, Article 12 and 13. So either there's a referral by Security Council, then it doesn't really matter which state is concerned, or we have a state party referral or a proprio motu investigation by the prosecutor, and then we need to have a jurisdictional link. And in accordance to Article 12.2, this jurisdictional link can either be established by territory, so the crimes are being committed on the territory of the state party, or by nationality, active nationality, crimes are being committed by national of the state party. And this was already a compromise. It was a compromise between those that want to have a very strict regime of consent. The original statute of the International Law Commission had a case-to-case consent system of all states concerned. And on the other hand, states that were advocating for universal jurisdiction, arguing those are crimes that fall within the ambit of universal jurisdiction. When we have a few states that ratify it, well, we give the court universal jurisdiction. So in the end, territoriality and nationality were the compromises that one settled upon. And I think it's a very important point to make that the principle of territoriality is one of the basic principles that we have in jurisdiction, not only criminal jurisdiction, but any type of jurisdiction. But it's certainly one of the clauses that has led to controversies ever since. And if you look at the current discussions with regard to situations before the ICC that are not states parties, where alleged perpetrators are nationals of non-states parties, you will see that this is still a very current issue. Another compromise in Rome regarded the crime of aggression. There was no consensus at the time to include the crime, not so much because of the definition of the crime, but more because of the relationship of the International Criminal Court with the Security Council in relation to the crime of aggression. So the compromise that was found is in Article 5, that the crime of aggression falls within the jurisdiction of the court from the very beginning. You want from 1998, or if you want from 2002 when the statute entered into force, but the court cannot exercise this jurisdiction until a provision will be adopted that defines the crime and sets out the conditions for the exercise of jurisdiction. Now, Maria already mentioned it. This was being done in Kampala when an amendment was adopted to fulfill these provisions. And one might have thought, well, that's it. Now we have this provision. But there was another delay with regard to the activation. So if you look at what was adopted in Kampala, we have a definition, consensus adoption of a definition. The definition was already without discussion anymore in Kampala. There was already agreement before. The more controversial part were the conditions for the exercise of jurisdiction. And this goes back to Article 12 and the question of when the ICC should be able to exercise its jurisdiction over the crime of aggression. And the compromise that was reached in Kampala was to deviate from the default jurisdictional regime of the ICC, and in particular, to not allow the exercise of jurisdiction if only one state has ratified the Kampala Amendments. So in detail, if you have a look at Article 15 bis, paragraphs 4 and 5, the ICC can only exercise its jurisdiction over the crime of aggression if that crime is based on an act of aggression committed by a state party. In other words, if the crime is based on an act of aggression by a non-state party, the ICC cannot exercise its jurisdiction. That excludes all states, all non-state parties. And as if that were not enough, we have another paragraph that also includes nationals of non-state parties from being prosecuted in paragraph 5. With regards to states parties, in principle, the ICC can exercise its jurisdiction over such crimes, but states parties have a possibility to opt out of this reach of jurisdiction. So a state party that aggresses another state party that has ratified the Kampala Amendments, for instance, could have provided in advance a declaration that it does not accept the jurisdiction of the ICC over the crime of aggression, and then the ICC could not continue. So for me, having been in Kampala, this was the compromise of Kampala, but you may also be very well aware that there's some controversy over this particular interpretation. And we have a number of states that were insisting after Kampala that there's no need for such an opt-out declaration because they're already out of the system, not having ratified Kampala. So we have kind of an absolute exception or exemption from the jurisdiction of the court by non-state parties and a relative exception from the jurisdiction of the court for state parties. Why was this done? Political compromise. A majority of states was not particularly happy with this compromise, but one wanted to have a clear definition of the crime of aggression in the statute. There was a long discussion as to whether all trigger mechanisms were applicable to the crime of aggression, and successfully all those three, prosecutor, state party referral, Security Council referral, all three of them are applicable. There was a long discussion as to the relationship with the Security Council. And if you have a look at Article 15 bis, that's paragraph 6 and continuing, there's a coordination process with the Security Council, but the Security Council can ultimately not block activities by the ICC, by not, for instance, taking a decision that an act of aggression has taken place, which is something that the Security Council has failed to do for quite a long time. So these were kind of trade-offs, and the feeling was it is better to advance, coming back to the question of immunities, it's better to advance with this system, have the definition in the statute, and then see. But also kind of having in the back of their minds that this might not be the ideal solution, The resolution that adopts the provision in Kampala also foresees a mandatory review of the jurisdictional regime 7 years after the activation of the jurisdiction, which was also mentioned, happened in 2018. So there was a mandatory review foreseen for the year of 2025. And then the full-scale invasion happened. And this changed the political landscape. Suddenly you have aggression at the center of the political discussion, which it was not before. And we are suddenly in the strange situation that we have a permanent international criminal court that has jurisdiction over the situation in Ukraine, that has jurisdiction over the crime of aggression, but cannot exercise its jurisdiction over the crime of aggression committed against Ukraine. And for many states, this was just not acceptable at this point in time. So there was this discussion what to do. Many states were very willing to provide accountability for the crime of aggression against Ukraine. And interestingly, this also included some states that had been rather reluctant in the past when it came to the crime of aggression. But one of the reasonings at the time was that a treaty amendment would take too long, and one wanted to have a quick solution. I'm not sure whether this was fulfilled, but that was one part of the thinking. If one had changed the Rome Statute, there might still be an issue with regards to retroactivity, maybe not for the full-scale invasion, but for acts that started in 2014. So the decision was taken to go along with an ad hoc solution in the case of Ukraine. But many states felt uncomfortable with this. To create new ad hoc tribunals when we do have a permanent international criminal court, and also to set another example of double standards, that a tribunal is being created for one situation, but not for others. So a number of states, Liechtenstein, but Germany then also made it its policy to say, well, we support the Special Tribunal for the crime of aggression for this very specific case because political reason demands it, but we are also working towards a process of changing the ICC statute, that we will change the universal situation and that a similar situation will not occur in the future, that we have an ICC and it cannot exercise its jurisdiction. So on this two-tiered approach, a group of 5 states, cross-regional group, and we write it down, so not to forget anybody, Costa Rica, Germany, Sierra Leone, Slovenia, and Vanuatu, introduced a draft amendment to change the jurisdictional regime of the ICC statute over the crime of aggression. And I will refer to this as the harmonization amendment. And as mentioned, there was already a mandatory review foreseen for the jurisdiction of the ICC. So the idea was to convene in July of 2025 and ideally adopt an amendment to the Rome Statute that would align the jurisdictional regime of the crime of aggression with the one of the other war crimes. How could this be done? One could easily delete Article 15 bis, paragraph 4 and 5, the 2 sub-paragraphs that create the jurisdictional exceptions. The other option would be to use language from Article 12 and introduce this language into Article 15 bis. That was the proposal that was ultimately taken. And since we're here also representing KIPA, this was also a proposal that was elaborated and supported by the Global Institute for the Crime of Aggression. It's a technical difference. The result is the same. We have an alignment of the jurisdiction of all 4 core crimes that fall within the jurisdiction of the court. And most importantly, a state that ratifies the amended version of Kampala would be able to protect itself. This protection was one of the most important aspects in the success of the ratification of the Rome Statute, because states said, well, we want to protect ourselves, our citizens, from crimes being committed on our territory. And the same incentive is thought to be given to the crime of aggression now. Now, in Rome, in New York in 2025, and I must say that there was an enormous traction of political will that has built up. I organized an academic conference in October 2023 that, after a long time, had taken up the subject, also with state representatives and representatives of NGOs. And then within a very short period of time, and with the engagement of a core group of states, and there was also a group of friends then that at the end had more than 50 participants, there was broad agreement on this proposal to change the jurisdictional regime, but no consensus. There was a resistance of a number of states, as we see so often when it comes to the crime of aggression, that I would say were not against or were not openly against the amendment proposal, but basically refused to discuss the amendment proposal. So no decision was taken on the substance in July, but one could find a compromise that the amendment proposal remains on the table. There's a roadmap now for the discussions. A subgroup of the working group on amendments at the ASP, the Assembly of States Parties of the ICC, is discussing this until 2029, where states will reconvene in a special session and then hopefully take a decision on this proposal. And I will leave it with that. Thank you very much.
Thank you very much, Astrid. Thank you very much for familiarizing us with the most current developments. You say the word compromise will come again and again, and I think it will come. I added one more word, controversies. Looking for a third still word to add. On that note, it feels like that our panel is, I would say zigzag, but it's like a discussion between the Special Tribunal, the ICC. We go back now to the Special Tribunal again with Noel. Please, you have the floor to address, to share your thoughts, and your problematic about particular themes of this new development. You have the floor.
Thank you so much, Maria. Well, thank you very much for inviting me. I'm very much of a doctrinal scholar, so it's actually fascinating for me to listen to Dr. Ellis start talking about what's going on really with the tribunal, because I only read about it through the press, literally. So I'm more someone who's just reading the statute and trying to understand what was being done there. So I'm just going to share my thoughts about the Special Tribunal. So first, and that's something that Astrid mentioned before, is that it's filling the gap, actually, because the ICC can't do it. So we need something else. There's no point in going to the ICJ either. We might use the prohibition of the use of force, but not a crime of aggression as such. And there's a lot of question, indeed, a lot of controversy about whether is it really worth the money. We are talking about how much money we're going to spend on that, and I would say yes, because it sends a very clear message that no one is above the law. There is a strict prohibition on the use of force, and that needs to be reiterated. Just letting it go is not going to do any favor to international law. So I'm going to share my thoughts about a couple of items, literally. So one is the definition of a crime of aggression. So if you look at the Article 2 of the Tribunal Statute, it's very close to 8 bis ICC statute, but it's slightly different. So it's the first paragraph is exactly the same word by word. I went there, I just checked everything, it's the same. For the second, it's interesting because what the ICC statute refers to the specific acts which are listed in the United Nations General Assembly resolution on the crime of aggression, actually not the crime of an act of aggression, I should say, the statute of the Special Tribunal actually says, oh, well, it's about that particular resolution, which is quite interesting because it doesn't go and list every single item there. But the interesting thing there is that it also refers specifically to all the, and I quote here, relevant United Nations General Assembly resolution with respect to Ukraine. So it's very specifically saying whatever United Nations General Assembly resolution said before is going to be taken into account also. So that is quite interesting. And it also refers to a variety of resolutions that are mentioned the preamble of the agreement between the Council of Europe and Ukraine. So slightly different there, but I think it makes sense because after all, this is a special tribunal for the crime of aggression against Ukraine. I'm absolutely flabbergasted by paragraph 4. So maybe Dr. Ellis will know why this happens there, because I have no idea why all of a sudden we are talking about the war of aggression. Apart that this brings me back to Nuremberg trials or probably Ukrainian law. But why this was added, I don't know. If anyone knows, please let me know, because it makes no sense to have it there. That's a question for the panel for later. More seriously, so I mean, we all know that the crime of aggression is a leadership crime. This was said by the IMT, the International Military Tribunal in Nuremberg, very clearly. It says to initiate a war of aggression, here we go with that word, is not only an international crime, it is the famous supreme international crime, different only from other war crimes in that it contains within itself the accumulated evil of the whole. And when the International Law Commission in 2022 referred to the crime of aggression as a crime of leaders, and that's going to be very much my focus. That was already discussed before. So my first issue with the tribunal is about selectivity, because it's literally pick and choose. And that was I should mention that before, but the double standards again. And I would say that there was a lot of controversy about this, because you have some states have said, yes, we support that special tribunal. I'm thinking about the US. I mean, I was there with Beth Van Czech, was in Washington, and she explained to us, yes, we are going to support this special tribunal. And we looked on the room thinking, but you're not very much in favor of the ICC, are you? And especially not the crime of aggression. So there's this sort of hypocrisy from some states that support the tribunal, but then reject the ICC jurisdiction. Or here in the UK has some issues with the crime of aggression and the ICC, and yet we're there, supporting that special tribunal. So that was noted by a number of states, but commentators also. And there's a perception of political bias also, that the tribunal served geopolitical interests. I mean, it's all about Europe, the Western states, and so on. What about the rest of the world when others are being, attacked, invaded? No one seems to pay attention to it. So very much Eurocentric in a negative way. When I was looking at the selectivity, I thought, well, when was the last time there was a very clear violation of a provision of a use of force? Yes, we can go back to the Second World War, but I think there's another one that a lot of people forget. It's Kuwait. In 1991, Iraq just marched into Kuwait. I mean, within seconds, the Security Council reacted and said, well, that actually, we didn't even use the word aggression, but there was a breach of peace. Exactly. We didn't go that far to the aggression word yet. There was a breach of peace, better than the threat of peace anyway. But so it was very quickly condemned. And if you look at it, was there any tribunal into place? No. Well, actually, there's this Iraqi High Criminal Court. So I thought, okay, I'm going to go and look at it, because was there any reference to something mildly relating to provision of use of force? Yes, and there was something bizarre, I have to say. So Article 1, Second D, referred to Article 14, which gave the court the power to prosecute an individual for, and I quote, the abuse of position and the pursuit of policies that were about to lead to the threat of war or the use of the armed forces of Iraq against an Arab country, which Kuwait was, in accordance with Article 1 of Law Number 7 of 1958. So it did seem to allow for the prosecution of a crime of aggression. But when you actually look at what was done, they didn't prosecute Saddam Hussein for that. They prosecuted him for war crimes and crimes against humanity and genocide. And actually, he was put to death before we went to the next trial anyway. So here we really have a selectivity issue, I think. Why this tribunal and why not others? I mean, some of the people will say, well, what about the special tribunal on the use of force against Venezuela, Iran? You see what I mean? You get the drift. So obviously there's an issue with selectivity there. The other issue is legitimacy. And because a tribunal about aggression is about going after the leaders are going to say, but who are you to put me to trial? Remember Milosevic, came to the ICTY and had a massive rant about this illegitimacy of his tribunal. Charles Taylor did the same also. It's less spoken of, but he also said, well, what's that? Tribunal, why do I have to go and be before the special tribunal for Sierra Leone, for Sierra Leone? So really the problem with the leaders is that it's not only them we're challenging, it's the sovereignty of a state. And an act of aggression is an act of a state, fundamentally. So it's a question about sovereignty. Who are we as the international community, to judge them? And of course, as international law, we say, yes, of course, we are in the right place to judge them. But if you look at the Special Tribunal's statute, the jurisdiction is the territorial jurisdiction of Ukraine. We're not coming up with some sort of basis, far-fetched in international. We're not saying, no. Actually, these are crimes which are in the books in Ukraine, in Ukrainian law, and this is based on the territorial jurisdiction of Ukraine. There is no stronger basis in international than the territorial jurisdiction. No one can, complain about that. And also, there's been a broad international support through these United Nations General Assembly resolutions, the Parliamentary Assembly of the Council of Europe, also loads of resolutions very clearly stating this is this is a violation of the prohibition of the use of force. What I would, however, point out is that whereas pretty much 3/4 of this world has said that it was a prohibition of the use of force, a violation of prohibition of use of force, there was less interest and less support for the tribunal such. A lot of the states from the global south were much more shy in supporting the establishment of the tribunal. And I understand from what I have read that, in fact, Ukraine had put together a draft that they wanted to put to the United Nations General Assembly to have an international tribunal set up, and withdrew it because they didn't think that there would be enough support for the creation of a tribunal. This is what I read. Probably you are all more versed into this. You tell me if that's true or not. But there was probably less support for that tribunal, and the tribunal has been created within the European framework with the Council of Europe. So a lot of people actually see this as a European response to a European problem, and I've read a lot of commentary from members of the Council of Europe, but also Ukrainian lawyers, Minister of Foreign Affairs of Ukraine, saying, no, this is not just about Europe. This is a signal to the world that this is not allowed. So a broader message. For me, there are still some issues with this. Is the tribunal here really acting on behalf of the international community? Bearing in mind the Global South was not behind. We'll see how many states will go for the enlarged partial agreements who are outside of the European framework. That will send probably that more international message if we get them on board. But if it all depends on how much money they can contribute, the Global South, unfortunately, won't be there. I think the tribunal is really good in sending a message. It's what we call this expressive justice is really there. Has a message been received and understood? Perhaps not, if you look at what's going on in the world at the moment. So we really have to sort of bite our tongues here. Next issue I'd like to mention is the jurisdiction ratione personae. So in relation to who we are going to prosecute. So it's a personal jurisdiction. I quote, it's a person in a position effectively to exercise control over or to direct the political or military action of a state. That's the Article 2 of the statute. And then I quote further, who bear the greatest responsibility for the crime of aggression against Ukraine. That's Article 1. So we're really clearly looking at prosecuting the Troika, head of state, head of governments, prime ministers. No one says it's only Russia. So we could go Belarus also, to be honest. But even there, I think we can go beyond that Troika, because it refers to political and military action. So, top generals could definitely be put into there. We still have this word greatest responsibility that seems to be limiting to anyone really at the very top. If you remember, we had something similar with Special Court for Sierra Leone. It was also the greatest responsibility. And prosecution and appeals court, they all were debating, is that a limit on the jurisdiction or is that a guide for prosecutorial discretion? And I think in the end, the appeals court was settled on, no, there's a limit on jurisdiction. So we're really looking at people who are in leadership position. Look at the extraordinary chambers of the courts in Cambodia. They also have the greatest responsibility there. And here, it was quite interesting. So first, they came up with 10 defendants. They did a list. And then the international court prosecutor came and said, oh, could we ask add a couple of people? And it was like, we're not doing this. Very much a political decision, because some of the people who were supposed to be added to the list were a bit too close to the government. So it was an issue there. So yes, it could also be seen from a political perspective. The word of greatest responsibility also for me means that we're creating a narrative. So whoever we are going to indict are the people we think have the greatest responsibility. So we almost, as the international community, deciding on who they are. I've had some more thoughts about immunities and trial in absentia, but this was already dealt with before, so I'll stop here, but I'm happy to answer any questions on that.
Thank you very much. Thank you very much, Noel, for problematizing us on issues of legitimacy, double standards, authority, and not only. I'm sure there will be many more questions and discussion among the panel, but also with the audience. And now I'd like to give the floor to David, as I say, last but not least. So maybe you will try to bring together, going back to the ICC, where like we started with the Special Tribunal, ICC back to the Special Tribunal, and now, closing this, if I say circle, back to the permanent court. And what does that mean for the ICC today? Thank you.
First of all, thank you so much, Maria, for the hospitality here in this wonderful Department of War Studies. Department of War.
Oh my God. Sounds
right. Studies. Correct.
Now I think you pay
Yes,
back for migration.
There is the rule of law. There is the rule of law. So wait and see. My duty is a little bit to put together everything, but also to indicate to you what are the actual obstacles. And the obstacles, they have names and surnames.
Oh dear.
On the 12th of September 2010, Mr. John Kerry was the Foreign Relations Committee chairman in the US Senate, wrote a letter that was published. It's unlinkable. It's not clickable. I have the actual link, and it's published in my stuff. And he said, we accomplished in Kampala what we didn't accomplish in Rome: protections for US service members. Mission accomplished, job well done. Okay. He was referring to especially the 5th paragraph of Article 15 bis, which of course Astrid presented very well, but also to the 4th paragraph of Article 15 bis, which is also illogical, because there is nothing that arises from nothing. There is that verb there that a lot of commentators have commented upon. Crime of aggression arises from an act of aggression of a state against another state. But maybe act of aggression arises from the planning and the initiation and the ordering by the leaders of a state who commit the crime, and then the event is the act of the state. And this is the same that happens in apartheid, which is a crime under international law. In Article 7, crimes against humanity, which cannot be imputed to the responsibility of any individual unless that individual controls the entire state apparatus, because it's an institutionalized regime of apartheid, of ensuring that there is institutional discrimination of one race, one racial group against another, like in South Africa until the end of apartheid. Same for the crime of enforced disappearance of persons. It cannot take place without denying to the victims access to the fate of their disappeared, of their dear ones. Under the law, if you don't instrumentalize the entire rule of law to ensure that disappearances, that those desaparecidos will never reappear, you cannot commit the enforced disappearance of persons. So it's not true that crime of aggression is different from other international crimes because you need an act of state. Also for other international crimes, and sometimes you always have to have an act of state, like apartheid and enforced disappearances. But let me tell you something more. What about genocide? Can you commit genocide if you don't either de jure or de facto control the territory through your own army, militias, whoever has the capability to destroy an entire group as such, as a whole, with the intent to destroy or in part? Am I right? Can there be a genocide committed by a non-state actor? Yes, but if the non-state actor arises to the level of a de facto state. And the same applies to all the international crimes. Why do we have Nuremberg? Because Nuremberg is born out of the necessity to criminalize the Nazi regime. So this fact that crime of aggression is different in nature is totally wrong and unacceptable. All international crimes are primarily crimes committed by and using the state apparatus, whether we like it or not. The problem is different. The problem is that the world order created after World War II introduced this word aggression under a certain article of the UN Charter. And there are some states, especially France and the People's Republic of China, who are repeating this mantra that they have the absolute monopoly on determining whether aggression has occurred or not. But first of all, in 80 years of history of the United Nations Security Council practice, and here I have colleagues who have written about the practice here in the room, from big universities like La Sapienza in Rome or University of Georgia. Other colleagues are here and can confirm this. There is not a single time, even in Kuwait, it was a breach to the peace. When earlier this year, under Chapter 7, we are talking about the year 2027, there are 2 resolutions that are adopted under Chapter 7 after the fully-fledged invasion of Ukraine by Russia. There are 3 resolutions regarding the situation in Haiti, and they authorize the use of force. And there is 1 resolution regarding the situation in the DRC. The Security Council orders Rwanda to withdraw its military forces from the territory of the Democratic Republic of the Congo. Orders. This is based on the evaluation, the determination under Article 39, that the situation in the Eastern Congo constitutes a threat to the peace. So the Security Council is not even able to ascertain whether aggression occurs or not. Why? It doesn't need to do so, because to trigger the powers under Chapter 7, it's enough to say there is a threat or a breach. Why to spend time in negotiating language on aggression? It's not substantive international law. It's not substantive international criminal law. You may argue, well, you cannot have state responsibility for aggression if the Security Council is not triggered. We are not talking about state responsibility. We are talking about individual criminal responsibility. If you go back to the last article of the ILC Articles on State Responsibility of 2001, beautifully written by Professor Crawford, notwithstanding the controversy that especially in Italy we supported other rapporteurs like Ago or Arangiuru, it's continued to level. Anyway, it's a beautiful document, and it says that there is an absolute separation and distinction between individual criminal responsibility and state responsibility. And one doesn't prejudice the other, and vice versa. And all the documents, be it advisory opinions, judgments, commentaries, they repeat this mantra, which is, of course, also repeated in the Rome Statute itself. So, in other words, this pretension that the Security Council must trigger somehow proceedings on aggression is so wrong that even in Kampala, and then I will go to the negative part of Kampala, but this is the positive one, even in Kampala, these states could not prevail. And we don't need at all, when the Security Council decides to refer a situation to the jurisdiction of the court from the 17th of July 2018, that referral in and of itself will establish the jurisdiction of the court regardless of the consent of the territorial state or other states implicated in that situation. And that will regard the 4 core crimes under international law, because that's the result of Article 15 ter adopted in Kampala, aligning it fully, repeating what we already have in Article 13b of the Rome Statute, which allows the Council to use the court as an ad hoc tribunal. Okay? But what happened in Kampala is that, unfortunately, states that really didn't want an independent exercise of international jurisdiction on the crime of aggression managed to obtain this exemption language that Astrid introduced, with all the caveats that she called upon for. And who's benefiting from this reality? Well, the main beneficiary of it, of course, is President Putin, which is carrying out an operation that maybe is a little bit different from all the others so far. For maybe what you can find in the letter A of paragraph 2 of Article 8 bis, where it repeats the formulation that you have not only an illegal use of force for the purpose of attacking another state, its territorial integrity, political independence, and in Kampala we added sovereignty as if it was necessary, but anyway, it's the same thing. But also for the purpose of occupation or annexation. And there is another aggravating factor that we didn't find with Saddam Hussein invading and annexing Kuwait, which is that if you exercise the collective right, inherent individual or collective right of self-defense, you will be subjected to a nuclear retaliation, nuclear weapons retaliation. That's what President Putin said in public. Am I right or not? On the record. It never happened in 80 years since the UN Charter exists. Am I correct or not? So I think that's why we need at least a special tribunal, at the very bare minimum. And to be honest with you, immunities do not even apply insofar as the jurisdiction of Ukraine is concerned. Because let's go back, where is the most recent description of the status quo of the law on personal immunity? It's not functional because those are gone. We go back to the arrest warrant case, Congo versus Belgium, right? And this stipulates that immunities exist among equals, among states, to safeguard the sacrosanct right of states to entertain peaceful diplomatic relations among equals. And no one can judge the other, as long as these relations are peaceful. But Russia invaded and started a war against and in Ukraine. So there are no peaceful relations between two states. I'm not the only one saying this. We can go back to writings of masters from the 19th century, which, for example, Professor Flavia Lattanzi picked up in a book in 1983. Even Professor Dapo Acante tried to refer to these pre-existing literature, also quoting Professor Browning, the late Professor Browning. He was immediately attacked, like as if he was saying something totally unacceptable. I think he was right on this one. So I think it's absolutely, the compromise is what it is. I think Mark was really graphic in illustrating how this compromise was reached. And I think we need to live with it. We need to work with it. But the real fix is in 2029, when we will have the opportunity of a second conference, a second special session of the Assembly of State Parties, where 2/3 of the state, there will not be consensus, there will not be unanimity in the room. We need to have 2/3 of the state parties to be ready to vote in favor. And this is what we did not have last summer in New York. Only 84 states were counted being present, and not all at the same time, and more than 10 of them had created objections. And of course, who was in the leading position? First and foremost, and quite surprisingly, quite shockingly, Canada. Canada was the state leading the sort of boycotting of the operation. with probably very good, intense negotiations between Ottawa and Washington on the issue of tariffs at the same time. So probably there was some inference there. It was the Prime Minister office dealing with this. But then, of course, it was France and the United Kingdom. Then the other, Australia and New Zealand. And then a group of Latin American countries led by Argentina that were unwilling to open up a new chapter in international law. So, of course, as you can see, many of these dynamics were relating to the current administration in the United States. So probably that's the main reason why it was decided to postpone a decision-making process to the year 2029, which is, by the way, nothing new, because also the Crimes Against Humanity treaty-making process is scheduled to take place in 2029 by the General Assembly. No surprise there that everything gets postponed at the UN due to this political situation that we are living in. So I think a very serious work needs to be done. Let me finish by saying one thing. The Rome Statute, the ICC system, international jurisdiction, domestic jurisdictions, ad hoc tribunal, even universal jurisdiction at the domestic level, all the exercise of territorial jurisdiction, they don't solve problems relating to peace, security, welfare and well-being of the world, development. We are not looking at, international law is what it is. It's international law. It's, of course, now it has become the major subject. Now the world is divided in two sides. Either you want peace with strength, or you want peace with dialogue. Either you are with the President Trump or with Pope Leo. The world is polarized, correct? I'm with the Pope, of course, as a good Roman. But I think what is important here to understand is that if the crime of aggression was lawfully, legitimately, I don't mind. Well, legitimacy. Let's talk about legitimacy in 100 years. Let's look at what's legal and what's not legal. All right. I think if it was legal to adjudicate in Nuremberg the Nazis who launched World War II, because after all, if you look at the list of the crimes, crimes against the peace, crimes against the war crimes, and crimes against humanity, the real main crime committed by the Axis powers, Italy, Japan, and National Socialist Germany, was the crime of aggression. If you look at the other crimes, you can find examples on different sides, correct? But absolutely, no doubt about it, there was one war of aggression within the framework of which the evil that contains the other evil, correct? It's not that I don't like the idea of a supreme crime. They're all equal. They can all be punished with life imprisonment. Pol Pot committed the worst crime against humanity of extermination, which in my view was not a genocide, but was worse because he killed 3 million people, more than any other after World War II, probably. But still, it's not genocide. It's crime against humanity. It doesn't matter that it's crime against humanity. But still, this is the unity of the corpus juris of international criminal law, crimes under international law. We have a duty to reinstate that unity of that corpus juris. We have a deadline for 2029. Only the state parties will have the right to vote. We can live without the vote of permanent members of the Security Council, but the clock is ticking, and I think it's very important that also here and elsewhere we create some sort of awareness that this is something that we need to do, because we cannot depend on the political will of the day. And, chapeau to the Ukrainian people and government also, who are really fighting a war to defend their statehood, to defend their freedom and democracy, their human rights, and also to do it through the rule of law, by invoking the intervention of international, and they're ready to be tried if they commit war crimes themselves, of course. They're submitted themselves to the jurisdictions, as the Palestinians do. A small digression. The only case before the ICC not based on territorial jurisdiction so far is the Hamas case, because this case took place in the territory of Israel. Just to say that when you accept to be bound by a treaty like the Rome Statute, you agree that your own nationals can be subjected to the jurisdiction of the court. I think we have a duty, and the year 2029 is really giving us an opportunity to make a very important reform in the international legal order that will do nothing more than bring us back to where we were in 1946.
Thank you. Thank you, David, for this very lively way to put things together. Thank you all very much. I told you before, I was looking for the third C word, so first I say crime of compromises, of controversies, and I would say of crisis. I know it's another C word we use in international law, especially when David say international law, it is what it is, which is actually now we don't know what it
Consensus.
consensus. Yeah, at some stage it's also of collaboration somehow.
Because it has could have a negative connotation.
Exactly. Yeah, that's true. However, having said that, and before I give the floor to you, but also to the panelists, whether you would like to add, we have about 40 minutes for discussion. I think lots of time to take your discussion comments and also to comment to each other, whatever you would like to highlight. I would like to say that if I can take less than a minute, that from your interventions, I highlighted three main themes. I would say maybe the second theme was not very, very vivid, but maybe you would like to comment. I'm curious on your thoughts. That's why. The first one is, speaking of compromises, the controversies, I spoke of use cogents, although I'm very skeptical about parental norms generally. But then we see from one side, what we teach in class, as I say, and then I get all these questions from students who happen, some of them to be here, and that you can note on that. But what's the point, when we have these massive violations, and then you speak about parental norms, and then we go to the draft articles of state responsibility, blah, blah, blah. So from one side, we see this, the language of parental norms. From the other side, we see a relativization with the crime of aggression, whether we talk about immunities or whether we talk about the jurisdictional framework. So that's one thing. I find there to be a kind of gap, if you want, an epistemic gap. That's how I would describe it. The second thing is something that maybe you didn't address if I fully followed you, but maybe you want to address it. It's about this humanization discussion about aggression. Like the whole idea, like the Human Rights Committee in General Comment 38 spoke that every arbitrary loss of life, every loss of life from an aggressive war is de facto, ipso facto arbitrary loss of life. So it brings back, the human rights discourse, and also the whole idea by many scholars that the crime of aggression is not a state, it's not a crime against sovereignty, but it's a crime against individuals per se, something that Tom Dannenbaum, but others have written. And the flip side of that is actually also the burden, the responsibility of law of soldiers who participate in aggression. That because, it's not against sovereignty, but it's about other human beings, that actually also plain soldiers should be a responsibility, or those who react, who refuse to participate, they should be entitled to asylum. How do you think, this humanization, which is brought into other parts of international criminal law, is coming also to aggression? And the third question, maybe then I stop, sure, it's more than a minute, is the normalization of the rhetoric of aggression that we have seen lately. And I'm going back from Putin to what we have seen the last months with President Trump, some incomprehensible comments of attacking for fun, bombarding for fun, obliterating entire civilization, that kind of thing. And also from other Western politicians who claim that we are in the post-international law era. And that came even from Chancellor Merz. He said, that maybe we should engage with something else than international law. So while you do all these things, to put together, to challenge this jurisdiction, what about the momentum? I would say the political and the legal, and I would say over moral momentum, the global moral momentum. And maybe that's where maybe you would like to think at the end, maybe to share that. And how do you feel? Should we open the floor? Do you want to comment or something?
Floor, but I have some comments to make. I will do that after, I'd like to hear from you.
Yeah, so I'm trying to take rounds of questions, if that's good. I will start with this side I will give the floor, 3-4. I will give the floor to the four of you. Yes, I have seen you. Please, you have the four flowers. Can you introduce yourself briefly, all of you?
Loud,
You know,
because
yeah.
the microphone is here.
Yeah.
Try my best. Hi, so I'm Najat Mustafa. I am a master's student here at King's. I'm doing my LLM here. And first of all, thank you so much for such an amazing panel. I really enjoyed it. I think my question connects to this idea of legal momentum and political momentum and will. I think the past couple of years, we've seen more than ever this sort of political and public outrage at crimes occurring in Gaza, in Lebanon, in Ukraine, in Sudan, and all these different areas. And there's this idea of, well, the public, we have to do something. We need the state to do something. We need movement. And I think my question relates to a point that Professor Noel made, where is this kind of strategy of creating specific tribunals for crimes of aggression that occur in Ukraine or in Iran or in Venezuela? Is this really a sustainable kind of tactic or strategy where if anything, it almost gives an opportunity for more anger from the public, because they could say, well, oh, you created a tribunal for Ukraine. Why not Venezuela? Why not Gaza? Why not Lebanon? And whether or not whatever occurred in those different territories is a crime of aggression, there is this idea that the public and laymen don't actually understand what is a crime of aggression, what's self-defense, what is genocide, and kind of the difference and interplay between those. I think you're even more at risk of a complete loss of faith in the international criminal system. So why is it that more support isn't being put into existing institutions like the ICC? Yeah.
Thank you so much. The gentleman in front, I will give you the floor to, please, you first. Yes, and then.
So my name is David Joss. I'm a criminal practitioner based here in London. I spent a number of years at the ICCY. I practiced at the ICC, but I do domestic work as well. Taking really what Mark said, I've got no problem as such with trials in absentia, even though I'm a common lawyer. And I'm not personally very interested in head of state immunity. That isn't, I'm not an academic, and I don't see it that way at all. But I am concerned about spending a lot of money on a tribunal, which will try people who are not there in person, flesh and blood. I mean, first of all, the tribunal is never going to be really very effective, because you will impose some bogus counsel on the absent defendant, and the absent defendant will never really have their say. But secondly, so it'll be a show trial. And secondly, haven't we in the international community doing this work learned from what happened in the Lebanon tribunal? I mean, my own view is the Lebanon tribunal, in the end, was a farce. And it was a farce for that very reason. And it collapsed, really, under the weight of almost those farcical conditions. And as much as I admire all the academics, and Mark has said on this panel today, my own view is that this is misguided, and a political solution in terms of the structure of any tribunal needs to be far more effective than what you have in mind.
Thank you very much. The gentleman in the corner.
Yeah, thank you very much. Ewan Brown, UK Defence Forum. I worked extensively, right, and in 2014, put a book on the table in front of staff of the EU delegate. So took out the crime and said, please, Tom Clancy and Mark Green command above. My question follows on from the previous gentleman, having worked nominally in Ukraine for the UN, I think it's pretty easy. I despise UN, though not everyone's living. For good reason. I'm worried about the naivety and other worldviews. You mentioned a lot the Kampala Conference. Now, I would just like to ask, did any ending make any references whatsoever to all the dodgy activities that have been going on for decades by the Russian people under the eyes of the UN at Entebbe Airport? A lot of interesting things happened there after 1970. And that has big implications for the war in DRC and elsewhere. And I just feel that you really haven't addressed the issue of how on earth to prosecute the winning side, because the winning side can give the legal equivalent of closing the 34 months and maximum reprisal against the country that we're from.
Thank you. Thank you. The gentleman in front, and will be the first round. Yes, please.
My name is Abdul Idris, and I'm the chairman of the Board as well association. I think you heard about the DAFA a lot. You are academic. Were subjected to the genocide 2 times. One is 2004, and one is recently the last October. About the aggression, we also have the other debate about the aggression because UAE support the militia and the community genocide and the crime against humanity. And there was the report from UN last month appeared that crime against humanity and war crime and through our advocacy in the United Kingdom, we disclose that there is a big gap between political agenda and international crime. You can say international law. You can say international law be political agenda, and this appear in when accused ICC prosecutor when they misconduct. And the three senior judge collectively clear him from all the charges. But BAE come and they say no, we don't believe in what the senior judge say. And here is the political agenda is coming. What I'm trying to say, even the academic or the social or the civil society organization, we did a lot of advocacy and we work hard with the pen and the paper and the voices. There's a political agenda draw us back from all our effort that we are doing. The best thing what you do, also if you want to talk about the aggression, there are many aggression happening. What happened in the Iraq? Aggression. What happened in the Venezuela is aggression. What happened in the aggression? What happened in the Ukraine? Aggression. It's all of the aggression. My question is why the world is a less support to the tribunal? Why one of you mentioned that the world is a less support to the tribunal of the Ukraine? Why that happened? And there were 2 tribunals happened. One is in Rwanda and one is in Sierra Leone. After that, an international criminal court set up. Okay. What the difference between the international criminal court and the tribunal? Why the international criminal court set up after these tribunals?
Thank you. I think, I think we are done with this round of questions. Maybe Mark, you would like to start commenting or responding?
I'm always reluctant to respond to a friend and that I admire all the work that he's done in this field. But so I'll try. I disagree on that. I think that, listen, trials in absentia have 2 imperatives. One is the demand for justice, and the other is the protection on the defendant, the accused. You're always trying to balance this. But for me, if you get the underlying issue for me is always victims, always. And if we're saying that for reasons of the challenges that we certainly will witness, this tribunal will witness in Russia on this tribunal, that we have no political will to create a process to respond to victims who are searching for some type of justice. It's not perfect justice. because trials in absentia are certainly not. But I simply can't get over the concern that I would have, or that I always had, of saying we're going to leave those victims alone. We can't handle this. Your voices are just going to be put aside. I personally am not willing to do that. But the solution is getting the ICC so that you don't have also this issue of legitimacy, because that's another issue that will come up. And I think that's why we continue to work towards normalizing, harmonizing the ICC process on this. Second, and let's remember that for Ukraine, there was an attempt to get the UN General Assembly with a 2/3 vote to support the creation of tribunal. That would have given the legitimacy. The Security Council was never in play, although again, the Security Council was in play for the creation of the ICTY, the ICTR. That's good. But that gets back to the political willingness. We could not get the UN General Assembly to move to a position, even though they had very strong resolutions against Russia's acts against Ukraine. But when it came to trying to push for the creation of a tribunal, it fell. The political willingness was not there. And so I get back to this issue. If the political willingness is not there, should we just leave it at that? That would have been the best situation with the UN General Assembly. Or do we find a new mechanism? I believe we find a new mechanism, not a perfect mechanism, but this is what we have. And I think it's a strong position for the international community. As to whether the points about the hypocrisy on this issue, there always will be, because the political willingness needs to be there. But I think this is an important step taken, and one that will not only respond to demands of the Ukrainians, but also it elevates the position of responding to the crime of aggression on the international scene. And that's what we need to do.
Thank you. Should I Astrid first and then Astrid?
Yes. Thank you. So I will not comment anymore on price in absentia because I think that's just
Whatever you want to comment.
answered, but maybe on the question of sustainability of ad hoc tribunals, no, they're not. And states also don't want them. It's a huge financial endeavor, and we have 125 states parties of the ICC statute. They don't want to have other tribunals because they want to strengthen the ICC. But technically, legally, that was the prevailing view. It's not possible to get the Ukrainian situation of the crime of aggression within the exercise of jurisdiction. The support at the General Assembly, I mean, there was never an official resolution that was being drafted. Of course, this was the first idea, and with the idea of the legitimacy, that you have as many states as possible backing the process. I mean, in principle, I think you don't need it, because international criminal law can be enforced by states. No? As one state can prosecute all those crimes. Ukraine has all the crimes, maybe not crimes against humanity, but they have more crimes than the crime of aggression, death, genocide. But of course, if we want to add political importance to international criminal justice, the desire is to have the broadest possible basis. But it's not an absolute prerequisite. And I've heard so many different accounts of what was going on at the time at the UN. There was a lot of going on in social media of people that were not even part of the process, of so many states that were against. I'm not sure, but the fact is that those states that were part of the core group that were also very much against the head of state or the irrelevance of head of state immunity were also not really in favor of establishing a tribunal that would have the full backing of the international community. Kampala and Tebe, no, it was not. You don't go into these negotiations with very concrete examples because this would heat up the discussion. One tries to be rather sterile. The other point is, of course, that you don't look back. If you create an ad hoc tribunal, it's something different. You can establish ad hoc tribunals for events that have taken place before, if that was already a crime at the time. But for the ICC, it was very clear that one would look to the future and not to past acts of aggression that may have happened because yes. Yeah, maybe I leave it at that.
Can I just add one thing, because that's an excellent point, and getting, sorry to interrupt. The idea of the UN General Assembly resolution, and there were a number of resolutions to the UN General Assembly directed at Russia. But when, as I say, when it came to the point of saying, could we get a resolution for the UN General Assembly to recommend the creation of an international tribunal, the numbers dropped. You just didn't have that support. Had you had that support, you also would have provided a greater position of saying this is an international, truly an international tribunal, and it gets back to what David said about the arrest warrant case. You could have made the case that this really is international, and therefore the head of state immunity issue is no longer relevant, which is exactly what the arrest warrant case indicates. But we just didn't get there. So instead, we were stuck with something that was much less than a UN General Assembly resolution in support of the International Tribunal. The UN Security Council was never in play. So you had to create something else. And this is where I agree that there's nothing that would stop the international community from creating a different modality, trying to find the consensus with as large a number of states that you can get, even though it meant, at least within the core group, that this tribunal would not reach that level truly international, which would have eliminated this head of state immunity discussion. That didn't.
Thank you, Noel, and then David. I think Noel, many questions about legitimacy, hypocrisy. Yeah,
I'll probably go back to the public outrage question. I mean, and that sort of goes back to your situation, because I remember in 2004 when the John Javid were committing the genocide, there's a lot of discussion about the G word, was that genocide or not? And at the time, it was what we call the CNN effect. Mm-hmm. So it was on TV and everybody was like, reacting, we've got to do something. And that seems to have completely gone, to be honest. Or the governments are not reacting to that CNN effect at all anymore. In relation to how we reacted to the ICTY and the ICTR, I remember being told that same thing. ICTY was all about Europe. There was a war in Europe. We had to react to it. Oh, something is happening in Rwanda. Do we really pay attention to that? South Africa, maybe not. And then eventually say, well, we still have to do something. And, then creating the ICTR. And then having enough and thinking, okay, well, this is not sustainable with these ad hoc tribunals. We need to create the ICC. I have a more fundamental question, in fact, about where we are at the moment with post-international law order or whatever. I mean, if you look back in history, war studies, so history.
What studies?
Exactly. Yes, studies. So does this world live in cycle? Because when you think about the First World War, we all realize, oh, wow, League of Nations, protection of minorities, because these were the issues that we faced. Second World War, human rights law and so on. So we started to have all these things. I mean, are we going into the depth of international law and then we'll come back the other way at some stage? I don't know. It's really, I think you have to take the long run, more the Chinese way, I think I would say. One question about how do you prosecute the winning side? I think, remember when I was one of the gentlemen there who asked that. I read very recently an article written by Labuda, and saying that and his view on how the Nuremberg trials were seen, because we actually only prosecuted the German Nazis when we think about what all other sides have done. But what also he said that even if we did only that, the Poles always ask, what about Katyn? No one actually looked at the massacre of Katyn either. So even within the Western world, we see things also very differently. And I think we've got to be much more nuanced in the way we look at who's the winner and who's the loser, because even within the winners and the losers, we are bottom losers, so to say, and different types of winners. So the ICC was supposed to be there to prosecute everyone, losers or winners. That's not working.
Thank you, David. And then I have another round of questions.
I think the political, and I take both of your questions here, LLM and the Darfur survivors. Thank you for being here. And I think the political momentum was there in the 1990s. So we had, we had the end of the so-called Cold War to a certain extent. China is still communist, but we call it the end of the Cold War. And then we had Professor of International Law, Boutros Ghali, Secretary General of the UN, called the decade of international law. Oh, yeah. And then we had a number of very important projects, started with the International Commission, then we had the ICTY, ICTR, then the Rome Statute in 98. And then many things changed, especially in my view, after the reaction of the global community to the 9/11 attacks against the United States, and especially in conjunction with the invasion, the illegal invasion, the war of aggression against Iraq. It's not the second Gulf War, it's an illegal invasion. And since then onward, the political momentum has gone down and down. But there is sort of a tipping point. There is a tipping point. And certainly what you have been mentioning now regarding the role of the United Arab Emirates in the conflict in Sudan is really illuminating. When I started to work on this topic about 2 years ago, I was seeing everybody shocked by what we were finding. But then, step by step, the outrage emerged. And there are now scholars who are saying that on the 15th of April 2023, the Rapid Support Forces, the formerly Janjaweed Alliance, would have not started the war against the Sudanese armed forces without having bank accounts, gold trade operations, legal entities, all incorporated in Abu Dhabi. Okay, and 7 of these entities are under current sanctions since January 2025 by the United States government, for example, unilateral restrictive measures, to be more correct. So, and there is a lot also that happened from the UN side. There are a lot of reports. So, the evidence is amassing. The evidence is amassing, and now it goes into Ethiopia being used as a basis for attacks. It goes into also the other side of the conflict, Egyptian territory being used to attack in support of the Sudanese armed forces. So in other words, even though crime of aggression is difficult to be proved in this case, because we have a non-state actor, we have a split within the state, and a section of the army becomes a rebels somehow, and you need to either prove either effective control or overall control by the UAE over the RSF, which is going to be very difficult. But nevertheless, you have a spotlight there, and there is something to work on, and let's hope that this will come to fruition. So a lot has been done more. Think about the Bashar al-Assad case in Paris. Quite an interesting trial that will start soon against a former head of state. I mean, many things are happening, notwithstanding the crisis. Okay, so the momentum can be rebuilt. But, we have criminal law since our liberal democracies or our civilization exists. Do not kill, right? Since the time of Moses, but still murder happens every day, correct? Murder, and there are places where there are so many, murder is so rampant, right? It's so dangerous to go there in certain cities. But still, the criminal code says that murder is murder, right? Yeah. So international law still exists. It's done in a certain way. It's a primitive system, horizontal, but it's deemed to come back because there is no other solution to the problems we are facing. And that's what we have. We have the UN, we have the ICC. The best thing to do, make them work, reform them, make them feasible to the problems that we have. Don't think that they can solve all the problems, of course, because a lot of socio-economic, political, they have to deal with political, social, economic means, not through the law only. But I think we should not give up.
Thank you. I have a couple of more questions from this side. Diane, you raised your hand before. And two more questions. Yes, Diane, you have the floor. Thank you.
Diane, I'm a professor at LSU Law School. And I'm going to begin with the caveat that it's always difficult to disagree with friends. I really struggle with this issue. I've struggled with it since before Kampala. I recall that the figure no less prominent than Richard Goldstone published an op-ed immediately before Kampala against activating the crime of aggression, with which I then was rather well persuaded. Events went differently in Kampala, but I have to say, this amazing panel today suggests to me that the issues around that, why it's so hard to figure out what to think about it, if you want an advocate, committed to one side are still there. It feels to me like whether something is a good idea depends on your metrics. And it's true of the International Criminal Justice Project writ large, it's definitely true of aggression. And one of the challenges, I think, for ICL since the 90s, two of the challenges. One is that the drafting project that led to the International Criminal Tribunals and that's the ICC tried to be a one-size-fits-all. Coming from federal criminal courts in the United States, where I was a defense practitioner for several years in transnational and international law course cases, I've never understood the victims and the preparations of the punishment and the everything in one. I understand politically why it has to be done because there will only be one institution. But it makes it hard ever to claim success in everything because it's operating on too many metrics. And so with regard to the tribunal on aggression, I just want to prevent this stuff. And a lot of times when we spend so much time in accountability, forget about prevention. I mean, why do we need all this? Because the Security Council doesn't work. If it did what it's supposed to do, then we wouldn't need all of this. I remember when we used to say, the best ICC would be the one that's no penalties, right? That never happened. And so sometimes thinking about where's the role for political solutions, how much needs to be invested in that, is an important question to which I don't have any answers at this point. And then the last thing that I'll bring in is I think another challenge is that the Nuremberg precedent is not what it was said to be in the 1990s. And some of that came out with regard to Petit, but also the only prosecution that anyone looks at on aggression was the INT Nuremberg. The subsequent tribunals after that had very checkered record, a lot of rejections of aggression charges. Yeah. Nobody wants to talk about the aggression convictions in Tocqueville because most historians feel they were really valid, that there's a lot to think about in that. And then there's nothing else for 80 years. So I think to talk about this legal precedent is a bit problematic, particularly because in the work that I'm doing on the Nuremberg history, why was it so successful? Because they forbade over and over again the defendants from ever getting any evidence challenging the behavior of the And so, spurious though they were, they were claims of self-defense or justification in relation to that war, which never reconciled at the tribunal. The same thing with Utopian defense lawyers who happen to be Americans, really hammered on that and they were excluded. And why is that important? not just because history is less stable than we think, but because if there ever is an aggression prosecution, someone like President Clinton or Donald J. Trump, it will be lawyers to the hilt. And these defenses, which sometimes have grains of truth, which sometimes sound like even if they're false, and look, speech, even before he launched the full-scale invasion. I use it in my PIL class, and my students are shocked at how possible these arguments of self-defense and all this are, unless you actually know what was happening. You bring that into a court, not going to build names and credit ever having attempted to prosecute. You might get in the middle. And so that's my mix of ambivalence about the project, as much as I am delighted to all I do it. I don't know what more to say.
Thank you so much, Diane. Okay, lots of food for you. I think two very short questions I have here, and then we will wrap up. You will have the floor. Yes.
Yeah, I'm an MA student at Cambridge International Relations. I just had a bit of a specific question regarding personnel. You mentioned about the kind of shyness of global South nations. I mean, that's quite expansive, but we'll just use it for now. I'm sure there's acceptance to it. And I was just curious about this because I think with the UN General Assembly meeting about recognizing the annexation in Ukraine, we see that there was, I think, 52 abstentions, roughly around that number, and it's saying that most of the South nations, and the arguments around this are often when global South nations do abstain from voting or do other forms, just essentially don't vote in favor. It's usually because of previous historical alignment movements, as well as this idea maybe that the judicial system has been often Western led. And I was just wondering if you could expand on that a little bit. And I wonder if that's the reason they haven't, global South nations generally haven't really chosen to be involved. And if so, if this is the issue, how do we go about addressing that and actually seeing them involved in a case for an international review? Right.
Thank you. And
Yes.
here, please, the final question.
Well, thank you so much for the amazing panel. I have a very quick question to Professor Catton. So I'm doing a PhD in international law, and my question is state fulfillment of international crimes. And you touched upon a very important point where you said as the crime of aggression, maybe we need to seek the element of these crimes committed by the use of state apparatus. Do you think in the crime of aggression, we can ever, at the UN level or between states, we can talk about the state policy element in the crime of aggression, while we do have it in crimes against humanity under Article 7 of the Rome Statute. And still states say it's not customary in international law. Some states are saying that, no, we don't need that requirement. It's not the requirement, it's just an element. I just wanted to know your idea.
Thank you. And now we have this enormous task to respond, and Astrid, not to miss your flight, So, Mark?
I'm going to respond to Diane, and again, same. I'm going to disagree on that point. First of all, I welcome the process where the defense, even Vladimir Putin, can present his reasons that suggest it was justifiable for the acts against Ukraine. I welcome that. I learned that actually with Justice Goldstone on the Tottage case, when he said that the yardstick measurement of this first case will not be whether Mr. Tottage is found guilty, but whether he's perceived to have had a fair trial. And the same thing here, even at this level, even if for some reason Vladimir Putin was apprehended in the near future and brought in front of the tribunal, I think that type of process and the ability to put a defense, however absurd it is, and I will state that there is no justification for what Russia has done against Ukraine. I would feel very comfortable prosecuting that case. But yet I would be the first to say that process needs to be open. The defense needs to put his position out. I don't think, as you say, there would be any regret for that. I actually think it will bring a greater awareness of exactly what the individuals like Vladimir Putin sets out as reasons for what is a crime of aggression. So I support that whole position.
Thank you, Mark. Astrid.
A very quick comment on the global south, and not with regard to your question because it was not directed to me. But just to mention how African states really got into a leadership position with regard to the harmonization of the jurisdictional regime of the crime of aggression. And I'm thinking about the DRC, I'm thinking about Sierra Leone, and other states that really had a crucial role. So that just wanted, because I wanted to mention this before. I would like to come back to one point that you made. If we have enforcement mechanisms, they can be construed according to the needs. So we have international law, and I agree with what has been said. International law is here, and it's not being changed because a handful of state leaders don't obey to it or have rhetoric against it. We need more to change the law. But enforcement mechanisms, they are subject to compromise. And I think the best lesson from the Special Tribunal for the Crime of Aggression for states would be to change the jurisdictional regime of the ICC statute, because you do not want to be in the position to negotiate this in times of crisis. So rather have something that is established before than being in this position where you need to fight for it and need to deal with the political variables. So enforcement is different. You can use certain aspects, you do not need to use certain aspects. So having the Special Tribunal for the Crime of Aggression, which was established under international law, but maybe not with the participation of all states, and in a way we have this compromise with regard to personal immunities. It does not mean that the law has changed or that this is an acceptance of a certain position of the law. It's just that within this particular enforcement mechanism, there was a political compromise that was necessary for the establishment of the tribunal. And that included the question of personal immunity. The same argument goes for the jurisdictional regime. The jurisdictional regime in Kampala was not established because a state thought that there's a customary law that would require doing that. No, because there was an aim. And the question is always, do I try to fulfill my aim as much as possible, accepting certain pitfalls, or do I leave it and rather wait for a better timing? With regard to aggression, there's never a better timing. It's always bad, and it's never going to be better.
I think Mark wants to add something on your list.
I just want to add one thing before I go, because it hasn't really come up, and we need to focus on what the United States is going to do in relations to this trial. Trump administration has been very quiet, unusually quiet. They certainly have not responded the way they've responded to the ICC and the sanctions, but it intrigues me as to when the tribunal begins to operate. Will the United States, will the Trump administration become much more active aggressively to say this tribunal should not exist? And particularly if the United States or the Trump administration is in the position of trying to create some type of negotiating peace, Putin will not stand for a tribunal that's focused on him. What does the United States do on this in relations to the European Union, or in this case, the Council of Europe and others? That's a really unknown, but one I think we need to focus on and look carefully at what's being presented on.
Well, I'm dreadful about the prospect of truth social on this particular tribunal. No.
Yeah, so to your question on the global south, yeah, it's not a monolithic entity. Let's say there's no doubt about it. You just refer to the African states, they are, and you have the ones in Asia, and even there, and they are all split and so on. So yes, it's it's like the global north, it doesn't exist. The global south doesn't exist either. It's just, a shortcut. And you could go west, east, literally to an entire map like this. And even that would not work because we're not really aligned there. But I think a lot of the states have now also started to see that it's a multipolar world. So it's not, two sides anymore. And they have to reposition themselves, see where the interests are lying. And the interests are not necessarily about the law, about politics, about economic support also, and which we also should not forget that a lot of these global south sort of states have suffered from what the global north has done to them. Not only the entire discussion about colonialism, but also about being invaded, so they have to reposition themselves, and they cannot just simply say, "Oh, we're going just to support you because it sounds like the right thing to do." Some of these states are just not interested in what's going on in Ukraine at all, and it's not only the states; it's also the scholars. I remember a British International Studies Association, who's probably very well known here, organized a conference on Ukraine, and they were trying really hard to get a Global South scholar to come. And someone in the chat said, "But where are the Global South scholars?" And the chairperson said, "We tried. No one wanted to talk about it." So it seems to be a lack of interest, from the academic side, but also from the states. And also a lot of these states are like, "Well, I leave you to your double standards, hypocrisy, and so on. I'm not interested. Just leave it." In the past, they would vote with the abstention, so to say. That's how we were showing that they were against. For the first time with Ukraine, with this United Nations General Assembly resolution, they said, yes, this is an unlawful use of force. But when it came to this, the tribunal were like, no, we're not going that far.
No vote on the tribunal.
I know, because it was a draft. It was a draft, but what I understand is
not officially discussed.
Yeah, but everybody absolutely knew that putting a resolution in front of the UN for the creation of the tribunal, the word was out. It just wasn't going to go. I mean, it really wasn't.
But you cannot say that their numbers dropped when it was not being presented.
It did drop in the sense of what the resolution suggested at the start to condemn Russia against its invasion. And then the discussion started, and there was discussions about should we move into a UN General Assembly resolution on the creation of an international tribunal, and that simply would not have happened.
Let me say something on this, because we have been following the crimes against humanity negotiations.
Yeah.
There is a dynamic there. You have defense teams, not delegations. Who's representing Burkina Faso? He's a legal advisor who is online with the dictator. Who's intervening in Burkina Faso? Russia. Same for Mali. Same for Central African Republic. This is the global south. It's not anymore in the 1990s. Let's have multi-party democracy, open it up, bring freedom and democracy. Let's create international cooperation and so on and so forth. First of all, the so-called West made enormous mistakes. People, instead of being brought to justice, have been killed repeatedly with drones arriving from nowhere. And hundreds of members of the Somalian youth have been executed. And there was an applause in a press conference in Washington. With the drone, we killed this and that of that organization, whatever it's called, not Al-Qaeda, Al-Shabaab. They're still there. It didn't work and it's unlawful. So we are really much worse than where we were 30 years ago with the ad hoc tribunal formation. We have to be realistic and know. In the crimes against humanity negotiations, we have all these delegations that are thinking what can be done in respect of what's going on internally in their own countries, laws against LGBTIQ plus persons that amount to the crime of persecution, if applied in concrete. They are not applied normally. And other situations like that. So a lot of states are against, but not because they are against, because they have defense teams in the delegation for their heads of states and government or security sector authorities. So we live in another world, but we have to have the GA for the crimes against humanity. We need simple majority of present and voting. So it's going to pass. We have the 90 plus votes for sure. The ASP, you need 2/3 of the total number of state parties. And the problem is that We are not anymore with those, back in the 90s, who was chairing the drafting committee of the Rome Statute? Professor Bassioni. Who was chairing the Rome Conference? Ambassador Philip Kirsch. You had outstanding personalities who mobilized entire structures behind that process. Not to mention the Italian government also put a lot of money and efforts to get everybody in Rome for 5 weeks. It was not cheap. They made a law and they saved on it. Instead of 9 billion liras, they spent 6.5. They even funded the European
Euro, huh?
That was before the euro. It worked very beautifully. Everybody that needed an hotel paid had an hotel paid because they had to vote the last day, right? You need to have that level of engagement. Where is it? This is state. So, and when some of you mentioned Iran, Venezuela, also Iran is not a state party to the Rome Statute. Forget about that. As long as they don't become a member, they're out. Their territory is not protected. Same for Lebanon. Venezuela is different, but I don't want to open that chapter because I think I have a position different from the mainstream. I think what we need to do, and I want to answer to Professor Amano on the issue of victims. We cannot have international criminal justice without implementing Article 2, Paragraph 3 of the ICCPR and the right to justice, the right to have an effective, available, and enforceable remedy for the victims of the most serious violations of human rights and international law amounting to war crimes, genocide, crimes against humanity, or the crime of aggression. This is my last point. Okay. Individual victims. The crime of aggression is not against the sovereignty of states anymore. We are seeing it every day. Yeah. All the poor Russian families deprived of their best youth. 1 million, maybe. 1 million Russian killed. They are all victims of the decision of their leaders to send them to an unlawful warfare. Similar discussion to be made for those who are resisting and defending their territory. They're losing their life. They are lawfully killed under IHL. They are a target of a military operation. IHL legalized murder, right? So that's what it, but they are protected by the crime of aggression. That's why we need the crime of aggression. That's our point. Of course, Tom Dannenbaum wrote a wonderful book, but we made that point in Kampala. That was our main point. There is a loophole of protection in international criminal law until and unless we have the crime of aggression properly addressed. Forget about it. And here we are, proliferation of international armed conflict today. It was seen, Professor Klaus Kress said, it was seen as an obsolete crime. Then it is not. Look at what we are witnessing. So I think, enough is enough. The small and medium power, the coalition of the willing meeting on the Strait of Hormuz, with all the Europeans and others, should also get together and make sure that this is also done. Why not? Well, can be done. It can be done.
Well, on that note, please join me in thank you, Sandro. I would like to say one more thing, that while we were talking, definitely the word is way more nuanced than it is depicted, reference to global south, global north, victims, everything. We need to every time to deconstruct layer after layer after layer. But when we were talking about compromises, I recently read a very interesting book, The Ethics of Compromise by Avishai Margalit. And it was all about the compromises we can make in response to peace. I strongly recommend it. I always, whatever I read, I tell students, read that. But it was very, very interesting about the ethics, because I think what is missing here and why they don't come together, I think what we miss here is leadership, and I would say not any leadership, but decent leadership. And this is much harder than what we believe, to have decent leadership. One final note, I want to thank very much Zala. Zala, thank you very much for organizing, for helping. Thank you very much, David, Mark, Astrid, and Noel, for being here. Thank you for proposing this event, for managing to co-host and co-organize, and thank you all. Looking forward to next events. Thank you.